state. It's sanctioned.
Yeah, okay, so because something's sanctioned, that's fine, good, and it's not traumatizing at all.
Do they give the prisoners guns before they shoot them?
Not saying it's
so
not
that it's justified?
traumatizing, but
I don't think that's how.
But why do you want to do it though? Why do you want to murder somebody?
Hey guys, mind make a
Why
room so
are
we can
you-
get this
oh,
guy inside,
hello.
please?
Oh my god,
Oh.
hello, Lady Clarkson.
All right. Come on in, sir.
Hi.
Afternoon.
I mean, I'd be one of several people
I'm
on the
gonna- I'm
firing
gonna
squad,
search the
Mora.
gun
It's not
then.
certain that I'd be the one that killed him.
Yeah, but why do you want to volunteer to do it though?
I'm dying.
Sounds like
Honey,
fun.
it's too cute. I can't handle
Fun?
it.
Oh my god, thank you. Thank you so much. He's so cute.
Something ain't
Best
right with
dressed
you, boy.
judiciary.
All right. In an effort to make things easy, do you want to just make a line and I'll search for people real quick and we'll get you inside?
Okay, me first.
Can we bring
Ooh,
guns
can
in?
you search me first?
No, nobody can bring guns in.
Your Honor, can we bring guns in?
No, only me. Oh, this is brandishing. Oopsie.
Wow, you're okay.
That was an accident.
The judge can bring a gun in, I guess.
Wow.
Okay.
Notice
you
how
are
I
good,
did the
Willow.
ask dad. Dad says no, ask mom.
You want
Approach.
in front of
to
me?
it.
or
Willow,
not?
Willow, you're
well,
good.
The
I
police
know, I want
can't-
searched
the
again.
police can't tell you no. in the
Oh my
courthouse.
god.
It's not their courthouse.
Let me slip you a gun. I'm just kidding. That would be very unprofessional.
What's
What do
in
you
your
think of my
cooler
outfit?
box, Judge?
It is Yuri, very special fingerprint bracelet from the deceased husband, and some miscellaneous chocolates. I was, and then I was again.
Officer,
First,
can
Liam
can
Cavanaugh,
chit chat.
and then Mr. Doc Hilliard.
Okay. You're good, Judge. You can go in.
Thank you. I was
hey,
going,
Willow, gotta shoot you
for
one
the
time.
record, I was coming in anyways.
Hey, Holmes is in there. He didn't get.
Oh my god, I love this outfit. I'm saving it.
Sonny, do you need me to bear with?
Excuse me.
So sorry. My voice was a little dry there. Do you need me to bear it for you or no?
Maybe? Oh god.
I feel like I have to be even cuter because of how cute you are.
I had a very dry throat for a moment there.
I don't know that you can beat this cuteness. This is so cute. You can try though. Good luck. Oh my god.
Did you get the wordle?
Now I'm working on it.
Is DLC around or not?
Yes.
Did you finally get to your court case though? Finally. Let's talk about how you want court cases. You finally got one, Sonny.
Yes, I'm excited.
I'm not. I can't be as cute as you, and I want to.
Oh my god, I get the word though. It is
What is it?
funny.
The hell?
Maybe we need to go shopping together.
We do again. It's been a while.
I just saw this together and it was so cute. I had to wear it. I think maybe a different top would look better with this skirt, but this is the one I am going with.
I feel like people would be really upset if I dressed like this.
Who is going to be upset?
Gupta?
Yeah.
I don't think there is a court clerk, and I don't think it's going to be video record, so he would have to show up. I have not seen him in a long time, so it would be nice to see.
Okay.
Would you like me to record it?
Oh, yeah. That would be very helpful.
I'm going to sit in the jury box, okay? So I'm going to go to meditate. I'm going to meditate.
Okay.
He always meditating. He meditate in the middle of court.
There, am I cute?
You are very cute, but I think for the court, you are maybe missing a little bit of your clothes.
But it's okay, I'm a clerk today. Should I wear pants?
And maybe the rest of your shirt. Haha. No, you look fine. You look cute.
Are you like a new Gupta?
No, God, no. Um, oh my God, I love those pants.
Oh my god, how about this outfit?
I love those pants. I don't know that the pink is the right matching. Because the pink in the pants is more orangey pink, and the pink in your top is more purpley pink. Oh my God. I think there was the orangey one.
I feel like if you don't wear a full shirt with this one, it makes you look kind of disproportionate.
Yeah, you're gonna need a bigger top than that, probably. Um,
No. I have this outfit. I can make it more cute. Oh, what about this?
oh, that is cute. I like. I approve. Now you needed the shoes. Oh my God, I'm stealing that outfit. Mine.
Do you like these shoes or is that too much?
Oh, that is very nice. I typically do not like to wear the heels because I don't like to be taller than most everybody.
See?
Ow! Fucking bitch. No biting. Alright, let me see. Where's my... Ah, this one. I'm gonna put this over here. I'm going to move this one over to here. And then I am going to duplicate. have not did a ruling in so long. I don't know. I feel like it is been so long since I've been to the court. I hope I'm remembering how.
I feel like none of these shoes work.
This were the flats. But I do have to go. It is almost 15 past. Time for the court to be starting.
Yeah, I'm not holding you back, am I?
Ah, I was waiting for you, but yeah, I guess not. You can go to the back and then go to the other back. Perfect. Okay, I'm going.
Oh, wait, you want me to be your clerk? I forgot.
Oh yeah. Find the shoes. Oh my god, so cute.
Let me put the sign up. Hello? How can I help you?
Oh my god, all rise. I am the judiciary and I am presiding, Sonny. Are there people still coming into the court?
I believe there is one more, Your Honor.
Sorry, I was hanging a sign up.
Speak now or be locked out.
All right, perfect. Let me see. We have the important people here. Defense, present, state present. We will be announcing the party shortly. Good evening. Judiciary Sunday Hilliard. We are being present today for criminal proceeding 2026 CM041, State of San Andreas versus defendant Eric Dunn. The court is thanking all of those that are being in the attendance today. The weather for court today is being respectful and professional. We are aiming to keep things smooth and drama-free, and to help with that, please be following these simple rules. Rule number 1, you must be being respectful to the court. This includes the judiciary, the court staff, and the legal process. We are going to be relaxed, but this is still being the courtroom. Attorneys and persons present today, you are to be maintaining the professionalism, presenting yourself appropriately, using the appropriate appropriate language, and be behaving appropriately. The conduct is being important, be respectful, and the court is being prepared to be putting the disruptive persons in the time out. For those of you that cannot infer, that is the contempt of court and in the prison cell. Thank you. Your electronic devices, they are a lot of fun. Please be silencing your phones. Don't pull out the cameras. And if your phone is ringing in my courtroom, it better be a ringtone that will be entertaining for all. Otherwise, your phone will belong to the court. And you will find yourself being outside. I actually do not know if I can confiscate the phone, but we will come to that if I need. See conversations. If you are needed to be speaking, do it in the whisper. Attorneys, talk it to the court only, not each other. No back and forces. And that is all.
Yes, Your Honor.
Wonderful. I did not request your firm to understand, but I appreciate that. Let me see the state. Who is being present today for the state?
State Prosecutor Scotty White, first chair, Your Honor.
Drej Sherba, DOJ paralegal, third chair.
He's moved to second, Your Honor, actually, since we got rid of the other first.
Perfect.
Second chair.
You are a chair. That is wonderful. Defense?
Hunter Yeager, public defender for the public defender's office, first chair.
Wonderful.
Matthew Jacobs, PDO, second chair.
And defendant?
Eric Dunn, defendant.
Wonderful, noted, Chair. Before proceeding, is there any pretrial motions?
None from the state, Your Honor.
None from the defense, Your Honor.
Not from the defense. Just from the court, I am recalling, reviewing the docket. The charges did be being amended to drop it the obstruction of justice charge. I have the 2 counts, aggravated murder, 2nd degree. Is there any other charges today?
The 1 times fleeing and eluding by foot, Your Honor.
1 count flee and elude by foot. Perfect. Okay, wonderful. Well, then let us be beginning. State the floor is being yours for the opening statement, unless you are choosing
Thank
to waive
you.
it.
Thank you so much, Your Honor. We are not, but we will be swift. May I approach the podium, Your Honor?
Yes, you may be approaching the podium.
Thank you so much. All right. Your Honor, today the state will be skipping the emotions and the fluff and the hullabaloo for our opening and stick with a simple outline of the facts today. As the court will hear from testimony and evidence presented throughout this trial, the defendant, Eric Dunn, stabbed 2 local victims. His DNA was found on the murder weapon. He had clothes on his person that not only matched the description of a witness of the crimes, but also had the DNA of both of the victims' articles of clothing. Furthermore, a victim's DNA was found on Mr. Dunn's hand. This alone would be more than enough to eliminate any reasonable doubt for the charges levied today, but the state will further present CCTV footage that will further solidify Mr. Dunn's culpability and presence on the scene. Thank you, Your Honor.
You are welcome. Defense?
The defense will be foregoing an opening statement, Your Honor.
Perfect. All right. State, the case is yours to be presenting. Any witness or evidence?
Thank you so much, Your Honor. All right. First, the state would like to introduce a couple of pieces of evidence. Exhibits I-1 and I-2, the affidavits of Emmy Dove and Layla Diaz.
Defense, what say you?
No objections, Your Honor.
Wonderful. Exhibits I-1 and I-2, affidavits Imedov, Leila Diaz, accepted to the evidence.
Thank you, Your Honor. Now, a couple last pieces of evidence before we get to our first witness. Based off of the affidavit of Emmy Dove, Exhibit I-1, there is testimony regarding the collection of fingerprints from the bike and as well as, sorry, one moment, Your Honor. I'm just getting my notes in order. Just that, really, and other information regarding the motorcycle in question. So, as such, the state would motion to admit, sorry, all of Exhibit E as well as the forensic report, which is Exhibit H1.
Defense, what say you?
We would be objecting on the basis of foundation for Exhibit H.
Your Honor, may I rebut?
Yes, you may do the rebuttal. I love the rebuttal.
Thank you so much. So the affidavit of Emmy Dove states that she pulled out a blood DNA kit to swab and test the blood, then swabbed the bike for blood and DNA. The results of said swabs can be found or forensically, investigated. They conducted forensics upon it, and that is the foundation for said forensic report. And the state does believe that to be more than sufficient.
Defense. I'm inclined to agree with defense on Exhibit H.
Your Honor, in the contents of the forensic report that the state collected from the Major Crimes Division, there is not only the collection of blood samples that Officer Dove collected, which she testified to in her affidavit, but other pieces of evidence which have yet to have foundation established.
Your Honor, may I rebut once more?
I love every bottle, Mr. Scotty. Wait.
Thank you so much, Your Honor. So, yes, there is more than just that. For some reason, on this occasion, the forensics team made one enormous forensic report, but there is no real procedure for me to be able to set foundation for like 18 things at once before I admit the one piece of evidence. That wouldn't really be plausible. And we will build up to, during question and go through each of these with their respective foundation, but uh, I can't build foundation for everything to admit parts of it. That wouldn't work. I wouldn't be able to admit this till the very end of the case, and that would be unreasonable, Your Honor. So it is the state's belief that if there is foundation for part of it, it should be admitted.
Anything further, defense?
Nothing further up. Oh.
Actually, Your Honor, we would then therefore object to the parts of the evidence that are not relevant to the DNA that Miss Dove specifically collected.
You are saying you are not objecting to the submission or an acceptance of this, so long as the not DNA forensic bicycle or bike evidence is not being considered until foundation is being laid for it?
Yes, Your Honor.
I am finding that to be amicable. The court will not be considering the additional information within this forensic report, Exhibit H1, until sufficient foundation laid for the remainder of the forensic report. Are you understanding, State?
Mostly, Your Honor. If I could clarify, would you like me to readmit it when we do get foundation for that amount, or should we just continue and ask questions with it reasonably flowing, and the defense are free to object to foundation if they believe there to be a lack thereof?
The court for how do I articulate this? Transparency would request the state to resubmit that second part of the forensics report H1 when foundation is laid for it. Does that make sense?
That does, Your Honor. If I could have one moment to get that together in my notes, that would be very much appreciated.
You have a moment. I don't know who did that one. What does this one say? I don't know.
All right, Your Honor. Should be set. And then to clarify, is Exhibit E all admitted as well?
Yes, no objecting.
Okay, and one final one. So, the court is only admitting currently the DNA from the bike. Is that correct, or all the DNA, or?
The forensic results of the evidence collected from the bike.
Okay. Understood. Fantastic. The state is ready to call the first witness when you are, Your Honor.
The
You
court is
for
ready.
it? Fantastic. The state would call Officer Dexter Cutter to the stand, please.
Mr. Cutter being present in the court.
Yeah, I'm here. I'm sorry. I didn't know if I needed permission to get up or not. I'm coming.
Mr. Darwish. Thank you. I don't know where is the corrections. I thought they said they call me.
Okay, raise your hand.
Yes, sir.
Do you want oath or affirmation?
Either one doesn't matter.
We can't hear you, Your Honor, Mr. Darwish.
Oh, okay. Make sure you're yelling. Okay, so everyone can hear
you're
you.
the one that wasn't.
I'm yelling as well.
Okay,
Yeah,
okay.
we're
I'm
good.
so sorry. Okay, you want oath? Okay. Do you swear to tell the whole truth and nothing but the truth, so help you God?
I do.
Alright, he's been sworn in.
Thank you, Mr. Darwish. The witness is being yours, Mr. Wait.
Thank you so much, Your Honor. May I approach?
Standing permission to be approaching the witness so long it is your turn for the questioning.
Thank you, Your Honor. All right. Good afternoon, Mr. Cutter. How are you today?
I'm doing pretty good. Thank you for asking.
Fantastic. Would you please state your name, rank, and department for the record?
Yeah, Dexter Cutter, corporal within the San Andreas State Police.
Fantastic. I'm going to get straight into it, Mr. Cutter. Was there a 911 call that led you to respond to the situation regarding this incident?
Yes, sir.
Your Honor, the state would move to enter Exhibit A1 and A3, which is the initial 911 call and then the report right before the 911 call.
A1 and A3.
Yes, Your
Defense.
No objections.
Wonderful. So admit.
Fantastic. Mr. Cutter, would you please open Exhibit A1 on your any device that you have?
Sure.
And when you have that open, can you confirm that's the 911 call in question?
That is the one, yes.
All right. Can you read the 911 calls out for the court, please?
Yeah, of course. It says, OMG, someone just stabbed 2 people here. Please help.
All right. And could you read A3 out for the court, please?
That was somebody calling in that somebody was attacking somebody within that area. It was a fight in progress.
Very good. And that was at the same location, approximately, correct?
Yes, sir.
Fantastic. Your Honor, the state would move to enter Exhibit H2, which is the map of the 911 calls. We're just going to use that for referencing purposes in regards to the questions we're about to have.
Objective from defense. Defense, are you here?
Oh, apologies, Your Honor. I thought you. Apologies, I thought I already said no objections.
Oh,
no
I'm
objections.
sorry. Court did not hear. Thank you. So I admit
Apologies.
H2.
Thank you. And Officer Cutter, could you please look at Exhibit H?
Yep, I got it up here.
All right. On that map, was this the call labeled first 911 call? Is that the location where it was?
Yes, sir. At the little motel.
And all right. Would you please tell me what you saw when you arrived on scene?
Yeah, there was a handful of locals kind of in the area. And then on the east side of the motel, I found two locals on the floor bleeding and a knife placed in between them.
Did these two victims survive their injury?
According to Saffer, who routed to the scene, they were pronounced DOA.
All right. Your Honor, the state would motion to admit exhibits B1 and B2.
B1, B2. Let me look. Any objecting from defense?
No, Your Honor.
Wonderful. B1, B2, so admit.
Thank you, Your Honor. All right. Officer Cutter, would you please look at those exhibits and tell me if those are the victims in question?
B1 and B2.
Yes.
All right, let me just pull these open real quick. Yes, can confirm.
Thank you. All right. And you said you found a knife on scene. Is that correct?
Yes, sir.
All right. Your Honor, the state would motion to sorry, the state would motion to enter exhibits B3A and B3B.
B3A, B3B.
Yeah.
Any objection from defense?
No objections at this time.
Wonderful. So admit B3A, 3B.
Thank you, Your Honor. Mr. Cutter, was this the knife that you found?
Yes, sir.
All right. Did you take any DNA swab of this knife? Oh, from this knife.
Yes, we did.
And was there any forensics conducted on that DNA?
Yes.
Your Honor, the state would motion to admit the relevant parts of the forensics report, Exhibit H1, regarding the knife.
Mm. Any objecting from defense?
None at this time.
Perfect.
All right. Mr. Cutter, could you please open Exhibit H1?
Yep, I got it open here.
Can you please read out the line starting with the with collection of knife?
Yes. Collection of knife. DNA matching both victims and fingerprints on handle of knife belonging to Eric Dunn.
All right. Thank you. All right. Did you take statement from any witnesses on the scene?
I did, in fact, yes.
And was this witness a local?
It was, yeah.
All right. Your Honor, the state would motion to enter Exhibit B4.
B4.
Yes, Your Honor, apologies. It does sound like we're playing bingo, right?
Defense, you are knowing my question. Any objecting?
No objections, Your Honor.
Wonderful. So I admit B4.
Thank you, Your Honor. Would you please open B4, Mr. Cutter?
Yep, got it open.
Could you please read out the statement?
Yes, the local gave a statement of a male wearing a white graphic tee and a blue starred helmet. Is about the only thing that they would remember, but they did mention that they left on a motorcycle.
Okay, and this was in reference to the perpetrator of the crime, correct?
Yes, it was somebody on scene who witnessed the entire scene.
Yeah, but the witness was stated that in regard to who they saw commit the crime. Yeah.
Oh, yes, sir.
Objection
Perfect.
leading.
Withdrawal. Uh, Let me rephrase, Your Honor.
Yes,
Um,
please.
the statement was the statement regarding the description of the perpetrator of the crime.
Yes.
All right. Did you provide the description of the suspect to any other officers?
Yes, I did. Would you like me to dive into that a little bit?
Yes, please.
All right. I was on a tack with Madeline Monroe and Layla Diaz while they were at the other scene, and I explained exactly what the local had explained to me.
All right, Your Honor, can I just have one moment to discuss with my co-counsel?
Sure.
Thank you.
Mm.
Perfect. All right. All right. Would you briefly tell us about the ongoings moving up to Mr. Dunn being apprehended from your perspective?
Uh, from my perspective, originally we were at the prison dealing with another call when a 911 came in that I routed to, which was the motel, which is where the two locals were found. While I was on the way, there was a separate 911. Um, Off the top of my head, I don't remember exactly what the 911 was about, but something along the lines of a man was seen here, looked like he was in a hunting accident, covered in blood, which is what Layla and Monroe routed to, where a man was seen on scene that they were in contact with.
Yep, and just briefly walk us through your involvement until the up to the apprehension, just to give us
Up
a little bit of found.
up to the okay, no problem. So when I was on scene of the DOAs, um, as the calls were pretty closely tied together, we had speculated at the moment that they could be tied. We found Mr. Eric Dunn standing next to a trailer who was shirtless, and a motorcycle was on scene. Due to the local's description of a motorcycle, we dove a little deeper into what was going on, but wasn't really getting much from Mr. Eric Dunn. Um, we He had a garbage bag that he was holding in his hand. Would not let us search and frisk it. Eventually, after speaking with him myself, he did approve of a frisk by myself. And as I was going in to do that, he decided to flee. A car pulled up and picked him up. Um, I was on a motorcycle at the time and followed the suspect, which led down into the city from Sandy, where the suspect was seen next to the Bobcat jumping out of the car and began running on foot. I chased him on foot, and when he attempted to climb up a ladder, I tased him, which is when he went down and needed medical attention.
All right, perfect. Thank you. Um, and then was the suspect processed and uh, placed under arrest?
Yes, while medical was en route, he was placed in cuffs.
All right. And did you partake in the processing of Mr. Dunn?
Yes, I did. I searched him
All
on
right,
scene.
very good. And did you find any articles of clothing in his possession?
I did. I found a T-shirt and a motorcycle helmet.
All right, Your Honor, the state would move to enter Exhibit F1.
F1. Any objecting defense?
No objections, Your Honor.
Your Honor,
Apologies.
the exhibit that they are entering is his the possessions of his pockets. Officer Cutter just stated he found clothing on the defendant, yet there is no. Oh, never mind. My apologies. I'm blind. No objection.
I was ready to give a spicy rebuttal, Your Honor, but I will hold my.
That is unfortunate. I would have liked to hear the rebuttal. It is
Well,
fine. I will
the
imagine.
night is young, Your.
Exhibit F1. Be admit.
Thank you, Your Honor. And I believe you mentioned this, but just to go over this a bit more clearly, were you able to identify what those articles of clothing were?
Yes, I was.
What were they?
One was a motorcycle helmet, and the other was a T-shirt. I could dive in a little more deeper into what those look like if you'd like.
Let's pause for one moment, and we'll let the picture do the talking, Mr. Cutter. Picture do the work of 1,000 words, or whatever they call it. Your Honor, the state would enter exhibits F2C, F2D, F3, and F3C through F. There's a lot of numbers in there.
F2C, F2D, F3C through F.
Yeah, precise.
Any objecting from defense?
No, not at this time, Your Honor.
If you are going to have the objecting to the submitting of the evidence, now would be being the time.
No objections.
Thank you. So admit, you may proceed.
All right, thank you, Your Honor. One.
Oh my god, I love court. You did a polygraph for a potential job today? Oh, that sounds fun. Not objecting at this time.
Right.
I don't know when else you go to
Please take a
object,
look
lady.
at those aforementioned exhibits and confirm. Let's do the shirt first. So let's do F2, C, and D first, please.
F2, C, and D, stand by. Okay, what's your question? Sorry.
No, I didn't say it yet. You're all good.
Perfect.
Just wanted you to open it so far. Okay, is
ready.
that the shirt in question that you found on his person?
Yes, it is.
All right. Now please look at 3C through F3, C through F, and tell me if that is the helmet that you found on his person.
That would be, in fact, yes.
All right. Does this helmet and this T-shirt match the description of the local's witness statement?
Yes, it does.
All right. Now, sorry to ruin a bit of hope for the defense in case this made it sound interesting for the ranking or the order of my questions. But before you modeled the clothing, was it swabbed for DNA?
Yes, both items were swabbed for DNA. Those swabs were put into evidence bags. I then modeled the clothing, and then they were placed back into evidence bags.
Fantastic. Your Honor, the state would motion to admit exhibits F2A, F2B, F3A, and F3B.
Defense, any objecting?
No objections.
Okay, give me one moment before you are proceeding. I have many things to consider.
Of course, Your Honor. And Your Honor, frankly, the state would be amenable to a maybe 2-minute tactical tinkle timeout recess if you would be, if that would be you.
Yes, you can have 2 minutes recess.
Thank you so much, Ron.
Does that mean I don't have to sit here?
No, you have to stay there.
Okay. Oh, I have to stay here?
Yeah.
Okay.
You're the witness, sir. You must stay put.
Yes, ma'am.
Boo! Yuck, you coulda boo!
I'll be back eventually. Oh my god, normally I would change. But I don't want to because I look so cute. Oh my god. Let's go try. See if we can find more cute. We just got to change this one. Let's see. Oh, I like the blue.
Go grass! Woo.
Oh, that is kind of cute. Not quite as cute. No, I don't like it with that shirt. Not the right color. No, no. Not the right color. Let's see. Try this one. No, I don't like that one either. No, I don't think there is another cute one. Let's try this one. Oh, let's see if there is one for this. No. We could do this one. I wore this one before. Is there not a brown one? Damn it. Okay, I'm going to cancel it. Alright. Let's go to change it. I couldn't find it. Pickle time out. Oh my god, I love corn. Like, I don't know it. Let me see. I need to look at the local one. Okay, stopped. It does say stopped. So I can read that. So that is important. And the local stopped. Okay, that is important. I thought he was going to forget to indicate how the victims became deceased. Because that was not covered. There was a knife found between them, DNA. I could infer, but I like, no doubt. I wonder what their arguments are going to be defense. Did everybody enjoy the mental team out?
Yeah, this little box was so much fun.
I hope
Absolutely, Your Honor.
Mr. Wheat did not take a tinkle break and remain within the court.
I did.
Your Honor, I have a pee-wee.
Okay.
No worry, Your Honor, I never desecrate the courtroom. I'm ready to go, Your Honor, when you...
Yes, please.
All right. Your Honor, the first thing is not for Mr. Cutter, actually, is for you. The state would move to admit the relevant parts of Exhibit H1, the forensics report regarding the DNA collected on the clothing.
That would be the collection from Yakit and t-shirt and hat, helmet.
Yeah.
Objecting from defense.
No objections.
Wonderful.
Fantastic. Oh, sorry, Your Honor, I didn't cut you off.
No, you're good. Admit.
Perfect. Thank you, Your Honor. All right. Mr. Cutter, would you please read out the line starting with collection of sample from jacket on the forensic?
It says collection of sample from jacket, the white graphic T-shirt, DNA matching both victims.
All right, and then read out the line starting with collection of blood samples. Hold on, having a moment. Oh, yeah, read out the line right below it, please, with collection of blood samples.
Collection of blood samples from T-shirt, DNA matching both victims.
Thank you. And the line under that with the hat, please.
Collection of hat, blue starred helmet, fingerprints on side returned to Eric Dunn.
Alrighty. Fantastic. All right. I am just going to ask a summarizing overview question, and then I'm going to quickly converse with Mr. Sherba to make sure we have nothing further for you. But for my question, just to summarize your testimony, please let me know if this is correct. You found Mr. DNA's. Good start. You found Mr. Dunn's DNA on the murder weapon. Mr. Dunn was in possession of clothing that matches a witness's description of the perpetrator, and the clothes found on Mr. Dunn's person had both of the victim's DNA on them as well as matched the witness's description. Is that all correct?
Yes, sir. All correct.
Fantastic. Your Honor, one moment to correspond with co-counsel, if you would. That's okay.
Yes.
Right.
Oh my god. Oh, the cute puppy. Got a picture.
That's all for direct, Your Honor.
Cross-examination time. Defense.
Thank you, Your Honor. All right. All right. Hello, Mr. Cutter. It's not a question, just a greeting.
Hello, not an answer, just a hello back.
All right. So, how many other people were in the area at the hotel when you arrived on scene?
I would say about 3 or 4 locals.
All right. Did the local who you questioned have any blood on him?
On them, no.
All right. Was there any other witness statements that you took?
That was the only local that would speak to me.
All right. Was there any blood in the area leading in a direction not east?
Sorry, can I ask the question one more time?
What? I'll rephrase it a little bit.
Okay,
was there
thank you.
a trail of blood in the area leading in a direction that was not east?
Off the top of my head, I don't recall.
Did you notice anything else suspicious in the area?
The locals on the ground with the knife.
Aside from that,
there was, I believe. Sorry, I'm not the best at court. Do I have a second to go over what's been admitted so far?
I would like to hear it from your words, but sure.
Thank you.
She allowed it. She didn't have to respond. I could have said. Thank you, though. I feel like that is my job, Miss Hunter. Jagger.
All right. Other than the locals, the medical attention, off the top of my head, I do not recall.
Where were the bodies of the victims taken to?
Sorry, you cut out the first part. Can you restate one time?
Sure. Where were the bodies of the victims victims taken to?
I believe the morgue, but that would be a Saffir question.
Was an autopsy ever filed?
I am unsure.
So you didn't file an autopsy?
I was not primary of the scene, no.
Okay. When did you read Eric his Miranda rights?
Relevant. That would be objection, comma, relevance. Apologies.
Objection to the relevance. When the Miranda rights did be being read. Rebuttal.
I don't see how that's irrelevant considering there was questions asked Eric when officers arrived on scene.
Do you have a rebuttal to the rebuttal? It is a custodial interrogation.
You're wrong.
Yes, I am the honor.
You are. We appreciate you.
Did you have something further to say?
Yes, I did, Your Honor. Your Honor, the state doesn't believe that any questions that would be requiring Miranda rights were asked of Mr. Dunn or received a response. And so we believe it would be irrelevant.
I have a rebuttal to the rebuttal if you want one.
Last rebuttal to rebuttal.
Any questions that could have been used as part of the investigation are absolutely relevant to this entire case. I mean, we need to know whether he answered those under Miranda or not, because then we can know if they can be, submitted as evidence or not, or if they can be referred to, really.
Well,
are you asking for permission for a rebuttal to the rebuttal of the rebuttaling?
You know me well, Your Honor, but this is a good one. I promise.
Okay, you have permission.
All right. First of all, Your Honor, no questions were asked regarding any testimony, or not testimony, statements made by Mr. Dunn from us. So that's a separate scope thing as well as relevance.
That is a better objection.
And furthermore, I'm gonna stick with that. Actually, I'm cool with that, Your Honor. I'm sticking with that. So we're adding scope to our objection list, Your Honor. That's the scope and relevance. We didn't ask anything about that, and this is cross-examination.
Are you having a rebuttal to the scope?
Yes, Your Honor. It is well within scope as Mr. Cutter over here described the situation of him asking these questions, though we don't know which ones, but him asking questions to Mr. Dunn at the scene.
I don't think it will matter whether or not he was Mirandized.
It is both, and it is within scope.
I can hear you, Mr. Wheat. Oh, you may continue, sorry.
You got anything else?
I did not mean to interrupt you, Miss Yekar.
That's all right, Your Honor. I was just finishing up saying that there is a complete relevance, and it was it's well within scope considering that Mr. Cutter described apologies, Your Honor. Described asking these questions and having contact with Mr. Dunn.
The court would agree. The objection I will note and will overrule. You may answer the question, Mr. Cotter, witness.
Can I get the question again, please?
Sure. The question is, when did you read Erica's Miranda rights?
To answer your question, I did not read him his Miranda rights. His Miranda rights were read by Madeline Monroe at the moment of detainment on their scene.
And that moment of detainment was not at the trailer park?
That was at the trailer park. I was not on scene at the time. I was at the motel.
Gotcha. Give me 1 second.
Wait, can you one more time for the court?
Sorry,
Did you
are you
say
asking me, Judge?
it was at the trailer park?
Yes, to easily clarify it, Monroe read him his rights at the trailer park when he was detained while I was still on scene at the motel. Or motel. I might have said hotel.
Thank you. I guess I could have reviewed the court record.
Do you know who may have handled the destination of the 2 victims' bodies?
As in the Zephyr?
No, as in the police.
Sorry, I don't understand the question. Can you rephrase it?
I'm asking if they're... If you're aware of if you're aware of which one of your coworkers filed an autopsy report.
Without having a 100% answer, I am unsure at this moment.
All right. No further questions at this time, Your Honor.
Wonderful. Redirect.
Your Honor, we're all set. We have no need for redirect.
Perfect. Anybody planning to recall this witness?
I believe the state is not.
The defense may wish to recall him at one point.
Your Honor, may the state be annoying?
I'm sure you will be either way. Go right ahead.
Thank you, Your Honor. Mr. Cutter here is not under subpoena. Furthermore, the defense never placed him on their witness list. So I would state that should Mr. Cutter have no interest in being called on direct examination, he should have the right to, upon his discretion, leave and
That
or
is
just
true.
not come up to the stand.
What say your defense?
Well,
That is a
defense
fair point.
says, nothing.
Perfect. Mr. Cutter, the defense may wish to call you on direct examination, but you are not under subpoena. They have not put you on a witness list, so they probably will not be able to call you, but you're free to go or stay as you are wishing. Whatever is making you happy.
Okay, thank you, Your Honor. May I step down now?
Yes, you may.
Thank you.
Oh, he is choosing to stay. Wonderful. Perfect. State, you may call it your next witness or present the next evidence.
State calls Officer Madeline Monroe.
Oh, Mr. Serba. Miss Monroe is being present. Mr. Darwish, are you prepared to be the bailiff?
Raise your right hand and make sure you're shouting so everyone can hear you, even from the noon, okay?
Okay.
All right, you want oath or affirmation?
Oh, God.
Affirmation, please.
Okay, do you solemnly affirm that you will tell the whole truth and nothing but the truth?
I do.
Okay, they've been sworn in.
Thank you.
Hello. Would you please state your name, rank, and department?
I am Madeline Monroe, senior officer with the SASPD.
Thank you. Was there a 911 call that led you to respond to the situation we're in court for today?
Yes.
State would like to enter Exhibit A2.
Exhibit A2. Objecting.
No objections.
Perfect. So admit.
Perfect. If you could pull up A2, please. That'll be line 20 on the docket. Let me know when you have it.
Oh.
I got it.
Was this the 911 call?
Yes.
And could you please read out that 911 call?
It says, "Hey, this is probably nothing but some hunter, but I just saw some guy walk into a trailer here with bloodied shirt and blood all over his hands."
Thank you. And that was over at the trailer park, correct?
Yes.
Thank you. When you arrived on scene, what did you see?
As we arrived on scene, we witnessed a shirtless male holding a trash bag at the trailer park.
Thank you. State would like to enter exhibits C1A and C1B.
Let me look. C1A and C1B. Many exhibits, just making sure I am noting. Defense.
No objections.
Perfect. So admit.
Perfect. Did you detain the individual while you were figuring out what was going on?
Yes.
And when you detained him, did you read him his Miranda rights?
Yes.
Did the suspect identify himself?
I don't recall.
Okay. Did you ask him for ID?
Yes.
Okay. State would like to enter Exhibit C2.
Exhibit C2. Objecting.
Apologies, Your Honor. Did you ask if I had a objection?
Listen, so I don't have to ask every time unless you are asserting an objection. The court will assume that you are not objecting. That way I don't have to keep asking you if you are objecting. Is that fair?
Yes.
Perfect. C2
Perfect.
admitted.
While detained, did the suspect comply and remain in your guys' custody?
For a short amount of time.
For a short amount of time. What happened after that short amount of time?
After he got frisked, Gray Gamma GTR pulled up, and he got in and fled from the scene.
Okay, perfect. Officer Cutter, in his testimony, stated that eventually he was apprehended and downed. After he was downed, did you collect any samples of the blood on his hands?
Yes.
State would like to enter all of Exhibit D.
Without objecting, Exhibit D admitted.
Perfect. We would also, based on Exhibit D, like to enter the relevant parts of the forensic report, the blood samples from the hands.
No objections.
Wonderful. So admitted.
Perfect. Officer Monroe, can you please open up the forensic report? Let me know when you have that open.
I got it.
In the forensic results, the second line, collection of blood samples from left hand, can you please read out that line?
It says results in a DNA match to one of the victims.
Perfect, thank you. While processing Eric Dunn, were his fingerprints scanned?
Yes.
State would enter Exhibit C3.
No objections.
One moment. C3 admitted.
Perfect. Were there any CCTV reports received for this incident, officer?
Yes.
Perfect. State would enter all of Exhibit G and the remaining bit of the forensic report regarding the CCTV footage.
Perfect. Are you reviewing?
No objections.
Perfect. So admit. Damn it. I can't.
Perfect. I hope you have the forensic report still open because I'm going to ask you to read out the CCTV footage section, if you please.
I shall also read the same.
Can you hear me? Yes, I have it open. Sorry.
Yes. Could you please read out the section at the bottom, CCTV footage?
All of it?
Yes.
Okay. Camera 1 and 2 would see a male on a black and green motorcycle wearing black camo pants, a white graphic t-shirt with blood on it, blue helmet with white stars, and purple in color shoes would be seen going west approximately 2 minutes before the 911 call would be placed. About 20 seconds before the 911 call was placed, the same bike and person would be seen traveling east. Prior to this, cameras 1 and 2 would have seen the same male driving towards the motel and leaving in the direction of Harmony Repair. Camera 3 and 4 would see the same man and bike about 1 minute after the initial 911 call drive past at high speed and pull into the dirt road leading to the trailer park. Nothing of interest is seen following that.
Thank you. If you could please pull up Exhibit E1A. Let me know when you have that.
Okay, yeah, I got it.
Is a, quote, black and green motorcycle, unquote, a fitting description of Eric Dunn's motorcycle that you found on scene?
Yes.
Perfect. Next, I'm going to ask you to pull up C1B.
All right, got it.
Okay, I'm going to ask you to look at his pants first.
Mm-hmm.
Excuse me. Is black camo pants a fitting description of the pants that Eric Dunn is wearing?
Correct.
And are his shoes, quote, purple in color?
Yes.
Okay. Next, I'm going to ask you to pull up F2C.
I got it up.
Okay. Is a, quote, white graphic t-shirt, quote, a fitting description of this shirt found in Eric Dunn's possession?
Yes.
And then finally, I'm going to ask you to pull up F3D.
Okay, I got it.
Is a, quote, blue helmet with white stars, quote, a fitting description of this helmet found in Eric Dunn's possession?
Yes.
Thank you. Your Honor, may I consult with my co-counsel for a moment?
Yes, you may. That is it.
State rests.
For this witness, Your
For this witness, sorry.
You are resting with this witness?
Yes.
Cross-examine? Defense?
Yes, Your Honor. Hello, Miss Diaz.
Hello.
Sorry, Miss Monroe, right?
Yeah.
Gotcha. Okay. So, were you primary for this entire situation?
Me and Layla Diaz.
All right. Where were the bodies of the victims taken to?
I was not there for that part.
We didn't ask about the bodies for her.
Is there an objection, Mr. Sierba?
Sorry, I wasn't. I was yelling. My bad. Apologies.
You may continue your questioning.
Do you know if an autopsy was ever filed?
I don't recall.
You don't recall? Okay. Is it common for officer? Never mind. One moment to talk to my co-counsel. Your Honor, the defense has no more questions for this witness.
Wonderful. Perfect. Since you stated rest with this witness, Lady Monroe, you are being free to go or stay, whatever is making you happy. You are not under subpoena.
Yay.
State any further witness or evidence?
No, Your Honor. The state rests.
Wonderful. Defense, the floor is yours.
Well, the state would like to call Miss Diaz up to the stand.
Your Honor, the state objects.
Defense,
Sorry, I didn't let
defense!
you
Wow,
finish.
that's crazy. Sorry, the defense. We are the defense. We are the defense. I hereby affirm, Your
that
Honor.
wasn't the issue. I'm still objecting. I'm objecting to the idea.
What is your objection to the idea, Mr. Whit?
Your Honor, I bet you could guess, but it is very similar to my previous one, which is she is not on the witness list.
Upon the reviewing of the docket, Miss Yeager, the court is noting that not on witness list. That was a good try, though.
The state does tip their cap to the
The defense rests their case.
Wonderful. Closing statement. Do you need the time?
Maybe like 5 minutes, Your Honor, if that would be acceptable for the defense and yourself.
5 minutes. Acceptable, defense?
Yes, Your Honor.
Wonderful.
Although we would like to raise a concern that we have about not having Miss Diaz on our witness list.
What is your concern?
Possible. Well, Miss Diaz had an affidavit submitted. We couldn't put her to our witness list because we were under the assumption she wouldn't be here. But she's sitting right there.
Where is docket?
Your Honor, may I rebut?
Yes, you may rebut.
They had all the time in the world to put Miss Diaz on their witness list, and they did not. It doesn't matter if she's here or they thought she was going to be or they didn't think she was going to be. They could have asked for a deposition or they could have put her on their witness list. It doesn't matter. She ain't there. She's also not subpoenaed by this court and has no requirement to testify, even if she were allowed to be called up, which the state asserts she should not because she's not on the witness list regardless of the defense's argument.
Defense, are you having a rebuttal to the rebuttal?
No, Your Honor.
Wonderful. The court will also note that upon the docket line 3838, where affidavit of Ms. Diaz is submitted, it is also assert Ms. Diaz did inform the state she may be able to also attend the trial date, but is tentative currently. I am just saying that. Are you requiring longer than 5 minutes for the closing statement preparing?
No, Your Honor.
Wonderful. I will see you all in 5 minutes. That is my only concern. 9:24. We go out at 9:30. I give them 6 minutes. I think that is how I will get to it. That is a problem, that there is not an autopsy report. I understand out of character why they did not seek an autopsy report, because they are but they are guilty. The problem I'm having is there is no autopsy report. So there could be doubt as to the cause of death of the victims. However, the witness statement from the local witness, where is it at? I don't know where is that. Jesus fuck. So many. Lots of locals description. Man wearing a graffiti about the only thing the worker would remember. Those mentioned they left on a motorcycle. This individual directly witnessed this stabbing. They should have asked more questions about that, but I would infer that if they are witnessing the stabbing, they might have also noted, although I don't know if there was no testimony, that the individuals were not already lying dead on the ground when they were stabbed. It is possible that the individuals, there is doubt as to what caused their death, but I would say that two individuals that nobody's saying, oh my god, these people are dead here. They are specifically saying someone just stabbed two people, and it does not indicate that they were maybe already dying or laying on the ground. So if they are not laying on the ground, they are stabbed and now they are dead, that you would infer that the cause of death would be being stabbed. I don't know. It is very complicated. But I understand why they did not get an autopsy report, because they are locals. We will see what they say in closing. Oh my god, I am back. We back in session. It has been 8 minutes. You are welcome.
State is all set, Your Honor.
Oh, wonderful. It has been 8 minutes. You are welcome for the extra minutes. Defense, you ready with the closing?
Sorry, yes, Your Honor.
Oh my god, that is perfect, State. The floor is yours.
Thank you, Your Honor. The state again will try to stick to the facts today. There is no need for fluff and emotions at this stage in the state's opinion. So, Your Honor, there is more than enough that this court heard for a finding of guilty on all charges. As the officers testified, Mr. Dunn's DNA was placed on the murder weapon. The victim's DNA is on articles of clothing that Mr. Dunn wore as seen on the CCTV footage and the forensic report that corroborated that it indeed was the victim's DNA. Furthermore, Mr. Dunn had blood on him that belonged to one of the victims. Then, to hit the final nail in this coffin, so to speak, the defendant was seen on camera heading in the direction of the murders before they took place, wearing exactly what a witness on scene stated the description of the perpetrator looked like, and then later had those clothes on his possession, or on his person in his possession. Finally, Mr. Dunn fled from officers Layla Diaz and Dexter Cutter on foot, as testified to by Officer Cutter in court and Officer Layla Diaz in her affidavit. The state believes this mountain of evidence proves well beyond a reasonable doubt that Mr. Dunn committed 2 counts of aggravated second-degree murder and fled from law enforcement on foot. Therefore, this state asked, or not this state, therefore, the state asked this court to find the defendant guilty on all counts. Thank you, Your Honor.
You are welcome. Defense.
Yes, Your Honor.
Stop knocking on my court door. Nobody going to answer it.
Oh.
You may continue.
All right. As heard during testimony today, despite there being efforts to collect evidence, absolutely no evidence was collected from the bodies of the victims. There is no autopsy. Both Dexter Cutter and Madeline Monroe testified that they were unsure, unaware of any autopsy done. If there is an autopsy and it hasn't been submitted, well, that's a whole other issue. But as far as we're aware, there was no autopsy done. And because there is no autopsy, there's no cause of death that has ever been asserted by medical professionals for this case. There also was no DNA swabs from the victims. There's no evidence that Eric Dunn ever touched them, only that his hand touched a knife that was not found in his possession. With only one 911 being put in about a stabbing and the state failing to establish whether that local that they talked to was the same one who put in the 911 call, we were left with more questions than answers as to who truly did it and what went down. Could Eric have tried to help the stabbing victims? Could he have touched the knife to provide medical aid? We don't know. These questions were left unanswered by the state's failure to thoroughly prove beyond a reasonable doubt that Eric Dunn. Some may say that the evidence is clear and concise, and to us, the defense, we say clear and concise is not the level the courts need to convict somebody. That would be beyond a reasonable doubt. Thank you.
You also are welcome. Okay, time for deliberating. I will be back eventually. I don't know. I want to find this bitch guilty. He killed these people. I want to find him guilty, but I don't know what else they could do. I mean, they could have done a forensic autopsy report. They could have processed the victims. She said maybe he was helping them. Mm. Hmm. Mm. Shit. Mm. Let me see. Flee and elude by foot. That one is easy. Guilty. He was in custody. He flee and elude by foot. Um. Let me see. Hmm. Oh my god, shut up, dog. Um,
Hey, Colby, I love you as much as the next person. Can you speak a little quieter, please?
the court would
Thank
also
you.
appreciate you speaking quiet. Thank you. How do I want to articulate this? Hold on, please. Mm, That was eventually. Mm. Thank you. I didn't want to interrupt your powwow. That was eventually. Let me see. Mm, the court today take everybody in attendance for the patience and attention during this proceeding. Both sides presenting much to be considering today. Undisputed facts today. The officers responded to multiple 911 calls in the Sandy Shores area, where two individuals are found to be deceased and stabbed near the Sandy Shores motel location. The suspect described it by a witness as wearing the black camo pants, the white graphic t-shirt, and a blue moto helmet with the stars. The suspect is described to live on a motorcycle. The 911 calls also indicating two persons being stabbed. 911 call indicate in the trailer park a man in bloody clothing on the black and green motorbike entering a trailer. The officers observing the defendant who identified on the scene with the presenting of the identification matched the description as described by the witness, consisting with the purple shoes and the black camo pants. Forensic evidence is indicating the victim DNA on the knife, suspect prints on the knife. Forensic evidence indicate victim DNA is on the clothing, t-shirt, and jacket of the defendant found on his person, and victim DNA is on the left hand of suspect. CCTV, I can't say that, letters. The footage is demonstrate an individual matching the description of the suspect traveled towards the motel location prior to the 911 call and then away from the location, being bloody after, but still before the 911 call, but later. And then is later being observed driving towards the trailer park on the green and black motorcycle. Also have the blood on his person. The officers detained the suspect at the scene of the trailer park and Mirandized, and defendant run and enter into the gray Gamma and flee at the scene. He later exit at the Bobcat location and did get apprehended and downed on the ground. In regards to the fleeing and elude on foot, the court is returned a very easy verdict of the guilty. As testified by the officers and witness, the defendant did be being Mirandized and did be being detained at the trailer park location, where he then did be fleeing from the detainment, using his feet to enter the Gamma vehicle as the passenger, and later exiting the vehicle and fleeing on the feet before being downed and taken into the custody. Very easy. In regard to the two counts, aggravated murder, second degree, the court is find that there is certainly being the abundance of the forensic evidence that are directly linked to defendant Eric Dunn to the death of the two victims. The victims are located at the Sandy Shores motel area, deceased with the clear evidence of the stab injuries. The CCTV demonstrate again the defendant approached the area, not bloody, and they be being bloodied when observed to be leaving, both prior to the 911 call. They would also be being seen approaching the trailer park area, were also observed being bloody on the green and black motorbike. Evidence is indicating that the clothing on the person of the defendant is matching the description provided by the witness, and the DNA of both victims are being found on the clothing of that was found on the defendant. There was being a knife document and recover on the scene of both victims, where DNA from both victims is found on the knife, and fingerprints returning to defendant also found on the knife. The defense today arguing the lack of the autopsy report no actual cause of death. And the lack of the processing the victims in question, perhaps there could be maybe another suspect, and maybe the defendant is only attempting to be assist the victims. Absent the autopsy report and any forensic processing of the victims, this court is left to be determined if there has been the sufficient evidence beyond a reasonable doubt that the stabbing did be being the cause of death and that the defendant did be being the cause of the stabbing. In making this determination, the court will note the eyewitness testimony obtained by the officer Dexter Cotter, who did assert to be being the direct witness to the individual matching the description of the defendant that is committing the stabbing. Furthermore, this testimony is consistent with the physical and forensic evidence presented throughout this trial, including the DNA imprints collected from the weapon in question, the knife that was recovered from the scene. The forensic evidence from the clothing recovered from the defendant is being consistent with the description of the witness, and the DNA of the victims is being on the clothing and the physical person of the defendant. Is there being the possibility that the two uninjured and stabbed individuals did become deceased from the unrelated injuries or illness? Maybe, but is it being the reasonable doubt? And the court today is finding no. As such, the court is finding defendant Eric Dunn to be being guilty of the 2 counts aggravated murder second degree. That is all. Is there being the sentencing recommendations?
Yes, Your Honor, and also I have some victim impact statements I received before this trial, if you would be okay with me sharing those now.
The court will, any objection, defense to victim impact statements? I'm going to allow them.
No, Your Honor.
Wonderful. Yes, please. I was going to allow it anyway.
Thank you.
You're
I
welcome.
will try to be swift with these. However, I will give them the respect that they deserve. These two victim impact statements are from the daughter of one victim, and the victim being Brian Firth, and his daughter is the writer of this statement. And then there will be a second one, which is going to be a statement from the mother of the second victim being Mitch Stein. Um, as the victim's family are not able to be here today, I will read it out on their behalf. So the first one is from the daughter of victim Brian Firth. My dad, Brian Firth, wasn't just a name or another person in the city. He was my whole world. He was the one I
No.
went to when I was scared, when I needed advice, or even when I just wanted to laugh. He had his way of making everything feel like it was going to be, no matter how bad things got. And now he's gone. Not by chance, not by fate, but because someone chose to take his life. I keep replaying everything in my head, wondering if there was something I could have said, something I could have done to keep him safe. I think about all the moments we were never going to have again. Birthdays, holidays, the simple things like sitting together and talking about our day. He'll never see me grow up, never be there for the big moments in my life, and that's something I have to carry with me forever. What hurts the most is how it happened. He didn't deserve fear in his final moments. He didn't deserve to have all his life taken from him like it meant nothing. To me, he meant everything. He still does. There's this emptiness now that I can't explain, like a part of me is just missing. People might move on, the city might forget, but I won't. I have to live every single day knowing my dad was taken from me in the worst possible way. I just hope whoever did this understands they didn't just take one life, they shattered an entire family. And that I will carry the pain with me for the rest of my life. Um, and Your Honor, uh, I can read the second victim impact statement here or post it to the docket, whichever you would prefer.
And the court will hear it.
Okay. This second one is from the
You're
mother
welcome.
of the second victim, Mitch Stein. Mitch Stein was my son, my child, from the moment I held him for the first time I knew my life would never be the same. He grew into someone I was so proud of, someone with his own path, his own struggles, but always my boy at heart. And now, because of someone else's actions, I have to live in a world where he no longer exists. There's no pain like losing a child, especially not like this. This wasn't an accident. This wasn't something that couldn't be helped. Someone made a decision, a choice, to take his life. And in doing so, they took a part of me with him. I wake up every morning hoping, just for a second, that it was all a nightmare. But then in reality sets in, and I remember that my son was murdered. I think about
Oh
the
no.
last time I saw him, the last words we shared. You never think those moments will be your last. There were so many things left unsaid, so many hugs I didn't know I'd never get to give again. A mother isn't supposed to bury her child. It goes against everything life is supposed to be.
Aw.
Whoever is responsible didn't just take my son, they destroyed a future, a family, and a mother's heart. That is something that can never be undone. Thank you, Ron.
Thank you.
All right. Your Honor, the court is prepared. The state now has its recommendation along with its justification.
One second.
May I proceed?
Yes, ma'am. Proceed.
All right. Your Honor, earlier the state said many times that that the trial itself wasn't the time for emotion and the non-factual parts of this. However, we do believe in at sentencing that's exactly what is most important to include because as testified to in the or as stated in the victim impact statements, Mr. Dunn didn't just simply you know, kill two random people that had no effect on anyone except those two poor victims. And even if he did, that would still be atrocious and not any less bad. But he also has affected the lives of many individuals, their loved ones, and family members who will never be able to have spend any time, touch, feel, hug, or receive any love from the victims. Mr. Dunn has committed absolutely awful acts against the victims. He has further shown contempt for this court and contempt for the state of San Andreas as a whole and its citizens by using the goodwill this court gave him, and attempting to flee justice before having to be dragged back by the Marshal Service. Doing so, even while on bail for this matter, he committed further crimes. The state does not believe Mr. Dunn has any semblance of remorse and believes that he is frankly a danger to the public should he be allowed to re-enter society. Therefore, the state believes it is the only punishment fitting for the crimes that have been committed and he has been
No, no.
subsequently found guilty of is life imprisonment without the possibility of parole. Thank you, Your Honor.
Uh, Defense. Maybe I should have did ask this before. Not been in court for a long time. Are you wishing to say anything, or defendant wish to say anything? Prior to sentencing recommendations.
Um, the defense recommends a sentence of 30 years with 6 years of parole afterwards.
Is there any justification for the recommendation?
We believe that our client is someone who is fully capable of being reformed, and that is perhaps shown by the fact that our client from what I was told at least, has never been arrested before, and this is the very first time that they have ever had a run-in with the law. Typically, when someone is less capable of being reformed, they have quite an extensive criminal history.
Your Honor, may I speak?
That is up to you and counsel.
Your Honor, I have conferred with my counsel. I would like to speak.
You may be speaking.
Firstly, I want to address why I ran, because I feel that's important. Before I came to San Andreas, I will admit I was in prison for 5 years for fraud. During that time in prison, I was repeatedly attacked. My eyesight permanently, what's the word I'm looking for? Affected. So quite frankly, I didn't want to go back to prison. My actions I'll admit were not great. When I ran into those two locals, they pushed me physically. And something just kind of snapped, I guess. Being thrown back to being attacked in prison, it was a hard time. I am sorry.
Okay. I will be back eventually. Let me see. Let me see what he wants. I don't care how long he wants. How long you want? Hmm. 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 Mm. Mm. Um. Um. Mm, okay, I will. Got this one. Oh my god. Hello there. Apologies for taking the time. No, I will not apologize for taking the time. It is my time. And this is a serious matter that is deserving of this serious consideration. Hmm. The court today did hear the sentencing recommendation from both parties, with the state asserting the life imprisonment without the parole is cited the severity of the crimes, the loss of to the families, and they are outlining the contemptuous behavior of the defendant as part of their justification. The defense recommending the 30 years imprisonment with 6 years parole to follow the release, and citing the lack of prior criminal history and the potential for the reformation. I am personally believe in every rehabilitation and the possibility for the reformation. It is always the hope of the court, but there are being some instances where perhaps people are being too far gone. The defendant today did be addressing the court with the apologizing, and they be assert the prior prison trauma is the cause for the actions. The court is finding the defendant's remarks to be being lackluster at the best. There was being the admittance of the wrongdoing, but also the very casual remarks. My actions were not great. No, defendant, Mr. Don, they were not great. And you did say, I'm sorry. Most of the remarks provided by defendant today was being the justification of the actions and the overall focus on himself, emphasizing his own suffering rather than the impact of his actions and how they did be affecting the others. As such, the court is finding the defendant's statement is not demonstrative of the genuine remorse or the acceptance of the responsibility. The court is acknowledging the defendant's prior trauma and the lack of violent repeat criminal history. However, the court is asserting today that the violent nature of the crimes and the resulting loss to the families and to the community, combined with the defendant's remarks and demonstrated disregard for the law and the court, are weighed heavily in the consideration for the sentencing. The court is finding the offenses brought before the court today to be the most serious in nature, and the loss of life is not something to be taken lightly. As such, the court is imposing the appropriate sentencing to reflect the gravity of the defendant's actions and the irreplaceable loss to the state. The defendant Eric Dunn is hereby being sentenced to the life imprisonment with the possibility of parole after the 30 years. The defendant Eric Dunn will be eligible to file for the parole April 24th. That is all. Wait, is there a fine? I didn't ask that.
The state would wanted to mention that. Sorry. May I speak? I apologize.
Yes, you may.
All right. The state wanted to mention that obviously, since we were going for life without possibility of parole, it would have been a bit arbitrary to shove a fine on as well. But since the sentence is allowing parole, the state would request a fine of $30,000. It believes it is very reasonable, $15,000 fine for each of those charges, as well as the whatever the amount for fleeing and looting is, which the state can figure out real quick, but it will be rather negligible compared to the other two.
Perfect. Defense, any recommendation for the fine?
No recommendations at this time, Your Honor. We would, aside from the fact that we would agree with the prosecution.
So at 30,200, Your Honor, I just did the math. Sorry, 200 for the fleeing and looting.
Wonderful. Defendant, Mr. Eric Dunn, 30 years, possibility of parole life in prison, excuse me, and the possibility of parole after the 30 years with a fine of $30,200. That is all.
Thank you, Your Honor.
You are welcome.
Now I go sleep.
Yeah, me too. I need to.
I am also going to sleep.
Oh my god, take me with you.
Okay. Let's go.
Oh my god, are they high-fiving?
I think they are, yeah.
We could ask, Your Honor.
Do I ask Sarah if he wants a bail hearing for my court case with him?
Cool, what?
What?
Oh. You have a court case with him?
Yeah, for those other charges from when they caught him.
Oh my god, did he plead not guilty to those?
Yeah.
Excuse me, Your Honor.
He might as well serve concurrently.
Yes?
Yes,
Yes, I have a question.
yes.
Lieutenant Gaston sent us up here. I assume we're taking the defendant with us, but are we charging the fine or is the state police?
I don't care who is charged the fine, so long
Okay.
as it is being
Okay,
charged.
guys, I'm gonna let you out of the courtroom.
You will
got it.
fight to the death to determine who gets to fight a certified.
Oh, if you go to fight to the death, can I watch?
No.
Oh.
That is not an order from the court, by the way. That would be on. I can't do that.
Can Willow watch?
No.
Why would I want to watch them? I want to.
All right, thank you, Your Honor. We'll take care of it.
I would assert corrections. You can do it. They are in your custody.
Thank you.
Thank you. But do I have to note on there that he is in prison for life? Do I have to say that? They know. They'll know, right?
Yes.
Oh, Mr. Macy, you missed the court.
I did. I'm sorry.
I can't believe it. My first court ever. It seems
Oh my
like
God.
Have a lovely night,
You're
Your
so
Honor.
happy.
Thank
You're
you
so
for your
happy now?
time.
I am so
I have
happy
a
now.
question.
We need to wait
The
another
plea
few
deal
months
is
for
not on
another
the
court
table,
case.
Mr. Dunn. If that's your question.
No, what about the time I've spent in prison? Does that
But
count
can someone
towards my
help me with
time?
the civil case I'm doing?
Oh, that
Mark
is
Kamar's not responding to me. It's
not
been like a day and a
my
half,
fault.
2 days now.
I don't know.
Is he
It
asking me that time?
wasn't really argued by your defense or requested before the verdict, so.
Yeah, no.
I
I
don't
say no.
think. Well, my defense didn't do anything, so.
No,
True,
yes,
they
or
get to go.
not,
Yeah,
obviously
that
not
is
now,
not
but-
true. They did bring up
I
one
didn't
weakness in the
get
state's
any
case.
witnesses. How am I supposed to argue a case with defense like that?
I think
someone
that's
help
for
me?
you, Sonny.
Oh.
Can someone help me not know
Shit.
later about the
Is
acid
the
seizure?
Judge Willow here?
That's me.
Can we quickly do a sentencing for my other docket?
Are you wishing to change your plea on that docket?
Yes, I don't require a lawyer.
DOJ, are you able to hang out for a minute?
Fine. You're not that wasn't meant to be sassy, Your Honor. I'm just very tired.
I am also tired.
Me three.
We're cool with the state is fine motioning for whatever the recommended amount is, as well as the obviously for the judge stuff it would be the whatever Judge DeHilliard ordered anyway. So
Mr.
do I
Dunn,
have-
the court. Oh, I'm sorry. I am interrupting
go
your
ahead,
court
go ahead, go
proceeding.
ahead.
The
No.
court will assert that you will be eligible for parole in 30 years on April 24, 2026.
Okay. And that's regardless of the time I've already been in prison.
To be fair, Mr. Dunn, you are in prison because you violated bail by fleeing the country and posted upon the docket that I will not repeat what you put on the docket.
You know what?
All right. Let's do this real quick so everyone can go to
Anyway,
bed, and then if you want to talk
again,
to
could
Sonny
anyone help me with the
about
acid
that.
seizure thing? Because
I don't
Malcolm
mind.
is not responding to me. It's been like a day and a half, 2 days.
Where is it?
It's gonna be
CD
docket
I don't remember the number, it's
049.
for Tyler
Mr.
Mendez.
Is it White?
Here, let us go to the back.
It is indeed, Your Honor.
Okay.
I also don't mean to interrupt. Do you mind if I just do my fine real quick for him?
Go for it. That's not.
Okay,
It's okay.
thanks, Willow.
We don't have to do it. We don't have to do it right now. We could do it another time. But I was just asking.
Oh, good. Do it tomorrow. I am very tired.
Yeah, that I was
And I have
asking
to
if
write
someone-
this ruling.
I thought that's what I was asking if someone can, so I know who to talk to after. So I know who to. Because Bank of
I don't know what it is.
Your Honor,
But sure, I will say yes.
the state
Is
would
it in the
recommend
employee file?
Yes, it's in the
100%
employee
honest.
file.
I'm assuming this is all correct upon the MDT, but also it doesn't matter too much. $9,700 fine and a
Where is it at?
250-month sentence.
Yesterday at 8:45.
Yesterday was
Wait, hold on.
25? No, 24.
I lied, Your Honor. Can I try again?
Yes.
All right. I read the notes. The state
Is it some sparks?
recommends a 330-month time
No.
and a
That is the Tyler
$14,300 fine.
Mendes one.
That's in total, including Judge Day Hilliard's contempt,
Oh,
which
what
was
was?
5,000.
Sorry,
Oh,
what was that total fine again?
Your Honor, actually, I'm looking at the charges on the docket here. I
Oh.
don't think I can plead guilty to this.
Oh my god.
Did you already plead guilty?
009.
Did he already do that, Your Honor?
Yes, not
What
yet.
are they requesting? They're requesting, is it for a civil suit in a non-responsive
He just requested
person
that.
and seizures for properties?
Which, if
Yes,
you want a
because
default
I
judgment, I can
default
do that.
judgment that the person had to pay a fine 149,000 something. I don't remember the exact amount.
I don't think that would
They
have
failed
be
to
in your
comply with the
best
order,
interest.
and then now the defense is arguing
To be
for
fair,
asset seizure.
hold
basically.
on, I can't hear anything because he is talking.
Well,
Are
not
you-
necessarily asset, basically just
This blonde
funds,
guy.
whether he has it in the bank or assets seizure, I guess.
There was. I did this once before. It was a long time ago. I am looking for.
It's okay. We don't do it right now. You focus on your doctor. I'm going to go to bed. Okay.
No, I am not even
Alright,
posting
got
this
that
ruling
for you,
tonight.
Mr. Dunn.
Well, I know, but I want to go to bed. It's very late for me.
I didn't.
I did this before.
try
I'll
to
have to
kill
find some
any-
emails.
wait,
I
no, I
know
definitely
that I
didn't.
had
plead
to.
guilty.
Well, this has been
I believe I had to
enlightening, Your Honor.
file
I
a
forgot I shot at
warrant.
the helicopter.
Alright, are you
Whoopsies.
pleading? Are you changing your plea to
Yes.
guilty to all?
Yes.
I had to
I
file
plead
for
guilty to
warrants
everything.
for the
Just to
information
be sure, that's 2 counts of
of the
aggravated
location of the
contempt of murder,
vehicles
evading arrest,
and the value of
obstruction of
properties.
justice, uttering threats, and then
I
you
don't
have your
really
contempt
remember
of
how it worked.
It's
Yeah,
okay.
I
We
did
can
all
figure
of
it out
that.
another time. I just
I
wanted
forgot
to
I
ask
shot at the
whether it's you or
helicopter.
someone else don't get it. I just want to make sure I can get this sorted in
All
this
right, we're
weekend.
not going to do time to find again.
So we don't have
Just,
to delay it
I have the
anymore.
time right now, but I need the fine again.
All right,
All right, I will
14,300.
figure. I will figure
I'll
it
be
out. I will
honest
look
with
for
you.
it tomorrow.
Okay.
Probably gonna
okay, thank you so much.
spend
I go bed.
20 years after
Yes,
I
me too.
get out, if I get out, working off that fine. Both
You
of
do
them.
also have to pay your friend back who bailed you out last time.
Oh,
Oh,
that's
God.
already been settled.
Alrighty. Okay. So I will accept a plea change of guilty.
All right,
for
I am
that.
going to
Do
sleep.
you
It is
have
very
any
late.
sentencing recommendations? Are you good with the
Yes,
default?
it could appeal. It is appealable.
Well,
I will
don't
tell you,
think the
it was
time's going
hard for me to
matter,
come to
but
the
I would like a
determination
lesser
because
fine.
there was no autopsy report. So technically, you could have argued that both individuals died from completely unrelated causes. Do I think that would have been reasonable to determine? No. No, I don't think so.
He did.
But
There's no reason to lower the fine in the state's opinion. He blatantly changed his plea to these counts, and there's no extenuating circumstances.
let me
The
go
state
here.
hopes that the court will
See
forgive
if there's
this fun
anybody for
figure of
berating.
To be fair, Your Honor, I never made a plea to these charges.
Oh, I have to. I gotta
before I
respond to the
pled
player
guilty.
report tomorrow. Shit.
Most people don't make a plea before they plea, but
Well, I wasn't given the opportunity to plead to those charges in the cell. And I
It's my
wasn't given an
birthday. Let's go
arraignment.
red. Yes, flashy unit. Shit.
cool, Your Honor, but the state maintains its.
wait, you didn't plead to these in the cell?
No, they sent me off and didn't take my plea.
Okay. It is
Got
pending
this correct,
arraignment
they
on the
did that.
docket, actually, so that's fair.
Let's go reading. Yes,
So
thank you for
consider it
hanging
the
out for
arraignment.
court. It was something. Interesting. I love
And
court.
I
It
guess
is my favorite.
took your plea of guilty. So.
Thank you for hanging out, watching, and making my heart happy. Have this sunny day and the
I
above
think,
average night.
honestly,
And
I'm just gonna let
what the
him.
fuck?
I'm gonna do the full time
Oh,
fine.
ready.
But you can serve your 330 months consecutively with your life sentence. So
It's concurrently.
really